Good evening, Sir Jerry. This is my special crime summary. The Anatomy of Crimes gives you an inside look at all the different fields of criminals forensics and their history, showing you how the investigation and evidence collection of crime has changed dramatically within the last 200 years, helping us find the truth behind more and more crimes. Special crime investigation, on the other hand, talks about the modern techniques in the investigation of serious and specific crimes including murder, homicide, rape, abortion, robbery, arson, kidnapping, blackmail, carnapping, and criminal negligence. The emphasis is on physical evidence rather than an extrajudicial confession. Special crime investigation focuses on specific crimes which by their nature are difficult and complex to investigate. The investigation process is a progression of activities or steps moving from evidence gathering tasks to information analysis to theory development and validation to forming reasonable ground to believe and finally to the arrest and charge of a suspect. The Criminal Investigation Unit is headed by a director with the rank of Chief Superintendent. A criminal investigation is also an art because it has the power in which that power can perform a certain actions that are acquired through experience and by observing. A criminal investigator is defined as a person who is in charge with the duty on carrying the objectives of criminal investigation. The one who identifies the guilty party and provide evidences of his guilt. A criminal investigator should be specialized wherein he must have adequate training and work experiences to develop the appropriate technical skills required of his position. He must be self-starting and highly motivated to carry out his assignments in the face of adversities or apparent hopelessness. And lastly, a criminal investigator should possess particular personal traits that will permit him fully exercise his investigative talents. The primary job of an investigator is to determine whether or not an offense has been committed under the law. The tools of an investigator in gathering facts are the following. Number 1. Information. Information, data gathered by an investigator from the persons including the victim himself and from the public records, private records, and modus operandi file. Number 2. Interrogation and interview. The skillful questioning of witnesses and suspects, while on the other hand, interview is the simple questioning of the person who cooperates with the investigator. An interrogator should be general knowledge, perseverance, logical mind, a power of self-control, and should not be alert. There are two types of interrogation, namely, narrative type. The interrogator gets the subject's story as narrated, and a question and answer type in which the subject is talking. The investigator must wait until the completion of the narration and then ask questions. Number 3. Instrumentation. Scientific examination of real evidence, application of instrument and methods of the physical sciences in detecting crime. Criminal investigation is an applied science that involves the study of facts that are used to inform criminal trials. A complete criminal investigation can include searching, interviews, interrogation, evidence collection, preservation, and various methods of investigations. Gathering records and preserving evidences in a crime scene is a necessary job in an investigation. An insufficient search or delay on the part of the investigator in conducting the search could affect the result of the investigation. Moreover, the investigator should be also consider or give extra care in crime scene operation since all the necessary evidence in connection of the crime are there. Furthermore, the investigator places himself at a spot where there are no physical evidence that will be tampered and makes an estimate at what form of search will be employed. There are 6 methods of search, namely, number 1, strip method. The area is blocked out in the form of rectangle. The searchers A, B, and C proceed slowly along paths parallel to one side of the rectangle. When a piece of evidence is found, The finder announces his discovery and a photographer is being called and the search must stop until the evidences has been cared for. Number 2. Double strip or grid method is a modification of strip search method. In here, the rectangle is traversed first parallel to the base then to a side. Number 3. Spiral or circular method. The searches follow each other in a path of spiral beginning on the outside and spiraling toward the center of the scene. Number 4. Zone method. The area the area subject to be searched is divided into quadrants and each one searches assigned into a specific quadrant. 5. Excuse. Well method is applied if the area to be searched is approximately circular or oval. The searches gather at the center of proceed radii or spokes. The setback of this method is that distances of the search increases as they proceed outward. 6. Line search method. This is variation of the strip search where multiple searches follow a single strip in one direction while on line with each other. Reconstructing a crime is made by the investigator after the crime scene investigation in how the crime is committed. After completion of the search, an effort must be made to determine from the appearance of the place and its object what actually occurred and what the circumstances of a crime were. The use of scientific methods, physical evidence, deductive and inductive reasoning, and their interrelationships to gain explicit knowledge of the series of events that surround the commission of a crime. There are the there are three components of investigative process are follows. Number 1, patterns. A series of similarities that may link particular cases or indicated that the same person is committing a serious crimes. Number 2, leads. Clues or pieces of information that aid in the progress of an investigation. Number 3, tips. Leads provided by citizens that aid in the progress of an investigation. 4. Theories. Beliefs regarding the case based on evidences, patterns, leads, tips, and other information developed or uncovered in a case. Scene of the crime of the Operation Republic Act 6975 Section 24 and Section 35 is a forensic procedure performed by trained personnel of the PNP Crime Laboratory through scientific methods of investigation for the purpose of preserving the crime scene, gathering information, documents, collection, and examination of all physical evidence. The mission of SOCO shall provide forensic expertise to criminal investigation by preserving, securing, and if need by the scientifically reconstructing the crime scene for collection, documentation, and forensic examination of all collected physical evidence with the end in view of establishing facts relative to a criminal incident. There are 5 objectives. Number 1, to conduct forensic investigations. Number 2, to enable the police to identify and arrest the criminal perpetrators. Number 3, to establish the facts. Number 4, to strictly adhere to the protocols. Number 5, to progressively acquire new technology and human skills. There are 6 functions. Number 1, it shall determine and delineate. Number 2, it shall preserve and ensure the protection. Number 3, it shall conduct methodical search. Number 4, it shall methodically document. Number 5, it shall methodically collect and transport all available physical evidence. Number 6, it shall present before any competent courts its findings. One of the essential parts in investigation is sketching the crime scene. This procedure aids investigator in getting to the bottom of the case and bring investigator close to the vital leads. Sketch is defined as the graphical representation of the scene of the crime, with the complete measurements of the relative distances of relevant objects and condition obtaining therein. Sketches are useful in the questioning of witness and suspect or writing of investigative reports. The sketches are also excellent companions to photographs. The importance of skits is that it refreshes the memory of the investigator, reflects the precise location of projects and their relationship to other objects and surroundings, assist the prosecutor and the judge understanding condition crime scene and to assist in questioning of witnesses and suspects. The authorized person who conducts that investigation are number 1, provincial and city fiscal, number 2, judge of court, number 3, justice of peace, number 4, director of NBI, number 5, chief of police, number 6, solicitor general. Stages of medico-legal investigation. Number 1, crime scene investigation. Investigation on the place where the crime is committed. Number 2, autopsy. Comprehensive study of a dead body performed by a trained physician employing recognized dissection procedures and techniques, which includes removal of tissue for further examination. Kinds of autopsies. Hospital or non-official autopsy. Number 2, medico-legal or official autopsy. The autopsy should be performed on a dead body whenever required by the special law. Upon order of a competent court, upon written request of police authorities, whenever the Solicitor General, Provincial, City Fiscal as authorized by the existing laws, and whenever the nearest kin shall be request in writing the authorities concerned in order to ascertain the cause of death. The persons who are authorized in performing an autopsies and dissections are health officers, medical officers of law enforcement agencies, and members of the medical staff or of accredited hospitals. The cause of death is the injury. Disease of the combination of both injury and disease responsible of initiating the trend or physiological disturbance, brief or prolonged, which procedure which produce the fatal termination. Kind of kind of cause of death. There are two kind cause of death. Number 1, immediate primary cause of death. This applies to cases in which the disease kills quickly that there is no opportunity for complication to develop. Number 2, the proximate secondary cause of death. The injury of disease was survived for a sufficiently prolonged interval which permitted the development of serious complication which actually caused the death. The mechanism of death is defined as the physiological derangement or biochemical disturbance incompatible with life which is initiated by the cause of death, wherein the matter of death is defined as the explanation as how the cause of death came into being or how cause of death arose. It may be natural or violent death. Natural when the fatality is caused solely by disease. Violent or unnatural death due to injury of any sort. Physical injury is defined as the effect of some forms of stimulus on the body, while the wound is defined as the solution of natural continuity of any tissue of the living body. Factors that responsible for physical injuries. Number 1, kinetic energy. Number 2, time. Number 3, area of transfer. Number 4, other factors. Vital reaction is defined as the sum total of reaction of tissue or organ to trauma. There are 4 crimes of physical injuries. Number 1, mutilation, the act of lopping or clipping of some parts of the living body. Number 2, serious physical injuries. Any person who shall wound, beat, or assault another shall be guilty of the crime of serious physical injuries. Number 3, less serious physical injuries. Any person who shall inflict upon another physical injuries which shall incapacitate the offended party for labor for 10 days or more. Number 4, slight physical injuries and maltreatment. The crime of slight physical injuries shall be punished by arresto minor when the offender has inflicted physical injuries which shall incapacitate the offended party for labor. Classification of wounds. Mortal wounds, caused immediately after infliction or shortly thereafter that is capable of causing death. Number 2. Non-mortal wounds, not capable of producing death immediately after infliction or shortly thereafter. There are special types of wounds. Number 1. Defense wound, results from resistance or self-protection. Number 2. Pattern wound, wound result from the nature and shape of an object or instrument which infers the object or instrument causing it. Number 3. Self-inflicted wound, wound produced on oneself. There are two medical classification of wounds. Number 1, closed wound. There is no breach of continuity of the skin or mucous membrane. Number 2, open wound. There is breach of continuity of the skin or mucous membrane. Death or physical injuries brought about by the powder propelled substance may be due to the following. Number 1, firearm. The injury is caused by the missile propelled by the explosion of gunpowder located in the cartridge shell and the rear of the missile. Number 2, detonation of high explosive. Explosion of the gunpowder inside a metallic container will cause fragmentation of the container. Things coming out from the gun muzzle after the fire. Number 1, bullet. Number 2, flame. Number 3, heated, compressed, and expanded gas. Number 4, gunpowder residue. Gunshot wound of entrance. The appearance of the gunshot wounds of entrance depends upon the following. Caliber of the wounding weapon. Number 2, characteristics inherent to the wound of entrance. Number 3, direction of the fire. Number 4, shape and composition of the bullet. Number 5, range. Number 6, kind of weapon. The odd and even rule is gunshot wounds. If the number of the gunshot wounds of entrance and exit found in the body of the victim is even, the presumption is that no bullet is lodged in the body. But if the number of the entrance and exit wound is odd, the presumption is that one or more bullets might have been lodged in the body. Concepts about sex crimes. Number 1. It is triggered by emotion. A person who commits a sex crime has control of his emotions. It is not something you can set out and analyze. It is a compulsion coming deep within the offender. Number 2. Gratification of the sex urge is often done in strange and morbid methods. It involves an addiction. Sex is a normal human need. Hence, this must be considered in the investigation of the sex crime. Number 3. Most sex offenders have their peculiar way to commit this crime. There are 3 important factors that be considered to produce physical evidence in trial. Number 1, that the article must be properly identified. Number 2, continuity or chain custody must be proven. Number 3, competency must be proved that the evidence is material and relevant. Physical evidence is defined as referring to any type of evidence having an object existence that is anything with size, shape, and dimension. There are kinds of physical evidence. Number 1, corpus delicti, objects or substances which are essentials part of the body of the crime. Number 2, associative evidence, evidence which links the suspects to the crime scene or offense. Example, fingerprints and shoe impressions. Number 3, tracing evidence, articles which assist the investigator on locating the suspect. Purpose of protecting physical evidence. Number 1, certain types of evidence such as Latin fingerprints are so fragile in nature that a slight act of carelessness in handling can destroy their value as clues and remove the possibility of obtaining from them any information which would further the investigation. It is necessary that the evidence presented in court be in conditions similar to that in which it was left at the time of the offense. Forms of evidence. Number 1, testimonial evidence, given an open court by witness who have knowledge of the facts. Number 2, Documentary evidence. Evidence that refers to public records, private writings, business records, photographs, maps, and like in the form of tangible objects or exhibits. That's all, sir. Thank you, sir, and God bless.